Yes, good morning.
Morning, my lord.
Mr. Carter, Mr. Chapman. Well, we've read what I hope are the necessary documents. We haven't had a respondent's replacement skeleton since June last year.
My lord, correct. Correct, yes.
Good. I'm not saying we necessarily should have done, but I just want to make sure that we've read what we needed to read. Because that was before Lady Justice Andrews made her order 2 days later, but you didn't feel the need to
Indeed.
throw something else at us.
I didn't feel the need to throw something else at you. I am, of course, prepared to make oral submissions.
Of course
today.
you are. I'm sure you are fine. Well, that's good. So we've read the skeleton arguments, we've read the judgment, we've had a look at some of the legal principles, but we think we're going to need some help in the first instance, if it's any help assistance to you, on some interpretation of the directive. And we start with, that's where we think we should start. But it's up to you entirely, Mr. Carter. I don't want to throw you off your stride, but that's something we think we will need at quite an early point. Okay?
Yes, thank you.
And are you able to say how you've divided the day?
We haven't discussed, I have to say, but for my part, I'm confident my submissions will be finished before lunch.
Good.
Which then leaves the respondent after
The rest,
lunch and
yes,
after short
okay.
lunch.
Well, I think that would be a good thing to aim for, Mr. Carter. Finish before that. Right. So, where do you want to go to first?
I will attempt to start, I think, by answering that point about interpretation of the directive.
I mean, don't feel you have to go straight there, but we think that's something we're going to look at quite early on.
Yes.
Okay.
Yes, thank you, my lord. I think perhaps in terms of setting out some of the background of that, the case of Hyde is helpful to some extent, and that's in the Authorities Bundle tab 5, starting at page 248.
Okay. Should we go there?
Yes, please.
All right.
And starting at page 252, paragraph 13, you've got the legislation.
Yeah.
I'll try to avoid reading it out, but as you turn and follow those paragraphs over the pages, you can see there's a...
Well, do we presumably need to look at some recitals, don't we?
Yes, I'll take you straight to the directive. So in the Authorities Bundle, my lord, at tab 2,
Yes.
page 18, you've
All
then
right.
got the recitals, the preamble.
Right. So let's start there. So, and which recitals do you say are particularly relevant?
Particularly 6, compliance with minimum requirements designed to guarantee a better standard, and then at the end to ensure the safety and health of workers. I think for my part, that's really the key recital of that.
So 6 and which other one? Or just 6?
I think really just 6, my lord. And then over the page on 9.
Would you just let me, for my part, just have a cast an eye over the others, just to make sure that we are not missing anything. Yes. So if I look at recital 11, it doesn't go beyond the necessary for achieving the desired objectives. And the desired objectives are what, do you say?
I say what's in recital 6, which is to guarantee a better standard of safety and health and to ensure the safety and health of workers.
Let us start with recital 3, which goes back to the treaty. Council may adopt by means of directives, minimum requirements for encouraging improvements, in particular the working environment, so as to protect workers' health and safety. That's the starting point. It's not dissimilar from recital 6, but that's the purpose for
It's
which
the
we
origin,
made
isn't
this legislation.
Yes. That's right.
So there are two critical features. One, this is a measure of minimum harmonisation.
Yes.
And so we have to work out what that bare minimum is, below which member states cannot derogate.
That's where my submissions, as we go through, I can try and give you the headline now, is that that's the wrong way around to look at it. So part of the respondent's case, I think, will be that even if we can rely on the direct effect on the directive, so what, because it doesn't guarantee us a civil remedy. Our case is that's the wrong way round.
All right.
As we go through Becker type liability,
Yeah.
Three Rivers,
Yeah, yeah.
actually you look at the purpose of the content of the directive, and then certainly what the Court of Appeal has said in Three Rivers is the reparation in English law simply means damages.
Okay, right. So that's helpful. Sorry.
Can I just pose what is the subsidiary question, which is member states may create a higher level of protection
Yes.
in relation to the irreducible minimum. The question, maybe perhaps the crux of the issue, is whether or not the legislature was intending to impose an obligation on the state to create a, if you like, a public law system of protection, or a public law and a private law system of protection.
Yes. That's a point where again our case will be that the respondent has fallen into error in this respect, and it's the wrong way to look at it. One has to be careful not to align the principles of effectiveness and equivalence with the concept of direct effect. And certainly I will be saying in Three Rivers there was no analysis or reliance at all on the principles of equivalence and direct effect. What I will be saying in my submissions is that Lord Hope ultimately in Three Rivers took the Becker test, which I will be saying actually he then used the Dillon-Coffer test, because he says in his judgment I think it's more precise. Right. And then that poses then the relevant three tests of the individual contents of the right. But the questions of remedy, I say, are a red herring, and really that's that the error there is aligning, as I say, the equivalence and effectiveness.
Okay. Now, that's a very helpful summary in shorthand. We're going to need to take it a bit more slowly than that as we go through. Okay. So you've identified the directives for us. Now, which of the provisions within the recitals in the directive? Which provisions within the directive do you rely on? I see there are some flagged. Is that what you say are the important ones?
On page 19, Article 3, particularly Article 3.1.
Right.
Under the heading Employer's Obligations, the employer, again, I won't read it out, but take measures necessary to ensure, and the key word there is suitable.
So we've read 3.1. Do you want to read anything else? Read 3?
No, not
Okay.
for us.
All right. Yes.
If I may then, perhaps it might be a convenient time to come on to our ground 3 to look at Three Rivers, because Three Rivers deals with a lot of these points as well, and I hope that will inform my submission. So if I may, I'll come on to ground 3 and answer these questions as we go.
Sure.
In terms of ground 3, the appellant's case is that under the principle of direct effect, it isn't a precondition to show that a member state has failed to implement a directive in whole or in part. That's just not a precondition, full stop. I will go through the case in a moment, but our case on that, the headline point is that it's clear on the face of Lord Hope's judgment that the question of a failure to implement is not a necessary step. And our primary position is that's clear on the face of the judgment itself. Our fallback position, which may be an abundance of caution point, but if it's not clear from Lord Hope himself, certainly he has gone beyond assuming what the Court of Appeal had said, and he has adopted what the Court of Appeal had said. So those are our 2 points on Lord Hope's judgment.
Well, then you're going to take us to Lord Hope's judgment straight away, then.
Yes.
Okay.
Just when you do, I'm not certain that point really addresses the dichotomy we've identified. Your point is that if there's a remedy in national law, you're not bound by it if it's directly effective. You can use European law, whatever may be the position in domestic law. Our question is, does the directive itself, in terms of the, if you like, the ratione materia, the scope,
Yes.
does it actually ever intend to confer a directly effective private right, as opposed to an obligation on the state to just implement through public law remedies or other remedies.
The objectives.
Yeah, so that's why our starting point is purely one of interpretation and scope.
I completely understand that. I had thought when preparing my submissions, and it was a dilemma because there's so much to unpick from Three Rivers.
Yes.
I didn't want to try to be helpful by skipping over and picking out certain parts.
No, understood.
My view ultimately was I was going to make my submissions by trying to take all of the points broadly together.
Okay.
But I promise that I will deal with that point.
Okay.
Okay. Right, we're going to Three Rivers. Is that where we want to go next?
Yes. I will start. I appreciate we've talked about what Lord Hope says, but I
You want to go to the Court of Appeal, do you?
Yes, please. The majority judgments, tab 13 in the authority.
So this is bundle 2. Thanks for the bundles, by the way. Well done, whoever did it.
No, thank you, my lord. So at tab 13, we've got at 519.
Do we need to understand what the case is about before we look at things in the abstract?
What's it
Yes.
about?
So explained who did what to whom that was said to be unlawful.
Yes. What I may do in that respect, then, I am going to jump forward to Lord Hope's judgment because he summarises what the plaintiff's case was, and that sets out the framework. Because there were so many issues in that case, of which community law was just one. If we go to page 655, then please, and then C, you've got the beginning of Lord Hope's judgment.
Yep.
You've got there under the heading community law a fairly long paragraph setting out.
Would you like us to read that paragraph?
Yes.
Okay.
Well, I think it would be helpful just so when I
Okay.
get to the next
In
one.
answer to my lord's question, what's it about? Yep.
Yes.
Okay, well, do you want to sit down while we do that? We'll read the paragraph down to H. BCCI. Yeah. Okay, well, we've read that first paragraph. Yeah.
And then after that, the next paragraph at the bottom that goes over the page is where you have a summary of what the plaintiff's community law argument was in that case. It starts shortly third, and you see before it turns over that the directive of 1977, which was the directive in that case, has direct effect.
Yeah.
And then over the page, particularly at B, you'll see there that
Be on which page?
over the page on 656.
Yeah. Yes.
Apologies, it's at C just above D. That being so, their community law rights under Directive 1977 must prevail over the requirement in national law to prove bad
Sorry,
faith.
where are you reading from? I just don't see it.
D.
Just above D, my lord.
Oh, D, I heard B, I'm so
No,
sorry.
I said B by mistake, I'm sorry, it's D.
That being so,
Yes.
Well, you need to read it all because the whole question was what was it intended to do, and it looks as if the plaintiffs were saying this was all about protecting the savings of depositors, and to achieve that purpose, that's the first question. What was the purpose? They say it was to save, protect the savings of depositors, and to achieve that it imposed obligations, and that being so, the rights, i.e. the rights to have their deposits saved, prevailed over the requirements for bad faith or dishonesty.
That's right, yes.
Yeah.
right.
And,
Yep.
and I will come back because Lord Hope obviously analyses in detail that particular directive.
What that's all about. Okay, right.
Um,
So now do you want us to take us back to the Court of Appeal?
yes, please.
And is this Lord Justice Old?
I was going to start with majority first, which was Lord Justices Hurst and Robert Walker
Yes.
at 519.
Before you go there, can I just check what E and F on 656 means? It looks, but you will tell me whether this is right, that on this basis they were assuming that the plaintiff's claim that it was to protect the depositors was correct. And then they went on to consider, on that basis, could you add additional requirements through bad faith or dishonesty via the misfeasance? So it doesn't look immediately as if they were addressing the key question of were the plaintiffs correct to say that the purpose was to protect the savings of depositors. Or is that wrong?
Well, the reason for the on the assumption point, my lord, is it arose in the context of a strikeout summary judgment application.
So they're assuming that they're right.
Yes, and there are large parts of the judgment later which then deal with principles of strikeout, which we don't need to worry about.
No, but they don't decide what the purpose of the directive was in this case, then, do they?
They do. Lord Hope does go on to do
Right,
that.
okay.
Okay. But thank you. You want to take us back to the majority decision in this court?
Yes, and just before I do, I suppose, just to explain my reasoning for doing it in this way, what I'm going to try and do is, first of all, I'm going to take your lordships to what I say is the legal framework, and then come on to how Lord Hope in particular applied that legal framework to this particular directive. And that's where the Court of Appeal judgment is relevant. At 519 then, at H.
A, did you say?
At H at the bottom.
H, sorry.
That's all right. It's just under the heading of European
It is.
law.
So, how much do you want us to read from here?
Of that page, that was just a useful signpost, my lord. It's just over the page on 520, please. Just under D, you've got the paragraph, the primary sources of obligations and rights.
Yes.
And then it cites Article 189 of the treaty.
Yes.
And then just above F from the treaty itself, the article itself, you'll see it says the directive shall be binding as the result to be achieved, but shall leave to national authorities the choice to form.
Yeah.
We're not saying otherwise. That's obviously something I'll come back to in terms of the question of the directive.
Quoting from Article 189 of the treaty, you
Yes.
rely on that. Yes.
So
The importance is that the starting point, I mean, it's no longer 189, of course, but as it was, the duty on the member state is to implement the result to be achieved, which takes you back to the scope and interpretation of what it is in the directive that's got to be implemented.
that's right. But then my position is that's looking at the rights under the directive in terms of the Becker or Dillon-Coffer stages, not under the does it require a civil law remedy.
Yeah.
Those are two separate points.
Okay.
Right. Well, come in for that one.
I-
You're going to develop that.
And my lords, if you feel if I'm teasing you on points or I apologise. It's just, as I say, when I've prepared it, I'm very conscious that
You understand.
I don't think teasing is the right word. I think interesting.
Frustrating.
Intrigue. Anyway, carry on. So where do we go after this?
Over on 521 then.
Yeah.
At C, we've got the position in relation to the effect directives was very clearly explained by the ECJ and Becker.
Becker.
And then
Are you going to take us to Becker, or is this going to be the best summary of it?
it's in your authorities bundle for now, my lord. Just in the quotation you've got.
That's enough.
That's enough.
Right.
At H, paragraph 22 of Becker.
Shall we just read that paragraph about what Becker was all about?
Yes.
Right. And then there's a quote. Do you want us to read that? 18 onwards?
For my part, paragraph 22 really is the particular point. Having looked at what was Article 189, they have binding effect, but it would be incompatible to exclude in principle the possibility of obligations being relied on by persons concerned.
Yes.
Again, looking at the quote very quickly, 18 to 25, what appears to be in issue there was that the German authorities were applying a German rule, and Mrs. Beck was saying, no, you can't apply that rule to me because that national rule is incompatible with the directive. It doesn't seem to be touching on the question that we're dealing with, which is whether the directive was intended to confer a system of protection or a system of civil liability.
And you're going to say that's the wrong way to look at it, aren't you?
Yeah.
On the facts, if I remember Becca,
Yes.
she was a credit negotiator.
Yes.
She said she was entitled to an exemption from tax, which was not conferred by national law, and she said my right comes from the directive.
That's right.
So there can't have been much doubt that she was enforcing a right applicable to her because it hit her in her pocket directly.
Yes, and the framework for deciding that was the Becker conditions, and she met those. The sufficiently precise for the
But
three stages.
that tracks back to the obligation in the directive to confer on her a private law exclusion from tax. So it comes back
Yes.
to a point of construction, I think.
I would
Under
say
the
not
directive.
necessarily private law, but it's in terms of does it confer a benefit on an individual?
On
or a
an
class of
individual,
individuals?
okay.
And then obviously what are the contents of the right
Yeah.
or the obligation,
Yeah.
and who's it relevant against?
Paragraph 22 doesn't. How far does it really take us? Paragraph 22 of Becker, because it says it's quite cautiously worded, wouldn't it? It says it's incompatible to exclude, in principle, the possibility.
Yes.
I mean that doesn't. Where does that get you in terms of whether
Well,
there is a an obligation being relied on personally?
well, there are one point to come back on that, but if I may, just quickly jumping ahead a couple of pages to 523, about the point about whether Becker actually was a clear case of a state failing to implement. This is a couple of pages later in the judgment at B, just above B, the other two qualifications. You can see there 4 lines from the bottom of that paragraph. Mrs. Becker succeeded even though the Federal Republic had a measure of discretion over such matters. I just make that point because we were discussing.
But I think I take the point that the directive was entitled to confer upon her an advantage,
Yes.
which was denied her in domestic law.
Yes.
You're right. I don't think it was expressed in terms of private law or public law right.
Yes.
But it was the nature of the obligation was personal in nature.
Yes. And that is then in the quote from Becker on page 522. We've got paragraph 25 of Becker that then gives us what's been later referred to as the Becker conditions.
Yeah. And then that Becker was followed in innumerable cases afterwards,
Yes.
more or less parroting the same rubric time and time
Yes.
again.
Right. Let's just read 25. Okay.
Did you want to say something?
Right. Go on.
On that point on paragraph 25, I'll come on to it where the Court of Appeal take the same approach, but you'll see from the bottom 3 or 4 lines there that there's a distinction between relying on a directive to effectively nullify an incompatible national provision and relying on the directive as a source of rights. And that's the claimant's argument in this case, just to be clear on that. And again,
So the seems to be relying on it.
It's the disjunctive or in the
Oh, yes, right. Yes.
so just and again, that I suppose ties into my overarching point about not to elide principles of equivalence, effectiveness, failure to implement with does the directive.
So
define
your case
right?
is that the directive defines rights which are particular to the individual, and you therefore say it follows that they can enforce them.
That's right, exactly. And on that point, it might be a convenient moment just to jump to another case that's in the bundle on that, which is at tab 21, the Cobblefret case. And at tab 21, page 907.
What is this concern?
Cobblefret.
What is it about again? You want us to go to very difficult to take context. You were criticised by the High Court, by the Circuit Judge for not taking one to the context of things. Very difficult to take things out of context. What was the issue again?
Sorry, apologies while I try and take you to the most convenient.
Interpretation of taxation directive. I mean, it recites
Again,
the
it
purpose
seems,
of the directive in the first paragraph, or third
it seems
paragraph.
to be a misfit between the national taxing legislation and the relevant EU legislation. The EU legislation said X, and the domestic legislation said Y. So that's all about. If that's the case, can you rely on on EU law to stop the application of national law? But one needs to understand the context.
No, noted, my lord, the point I say one can draw from that is at page 907, paragraph 61 that's marked up at the bottom over the page.
Right, let's read that.
To which the context is 58 to 60.
Exactly, yeah.
I mean, yes, so you say the mere fact that there is a discretion and a minimum requirement doesn't in and of itself preclude direct effect,
Yes.
which is probably uncontroversial. You don't preclude it in principle simply because there is a discretion or a minimum level of harmonisation required.
Yes. And then obviously the caveat is that provided the contents of the right can be determined with sufficient
Of course.
precision.
Then you get to 64, and the right that is conferred under that provision of EU law was an obligation to refrain from taxing profits. And that was worded in unequivocal terms, so you can get a remedy to give effect to that obligation, i.e. to stop them taxing profits. But that's what this is all about. You can rely on EU law to achieve what EU law says. And we know what EU law wanted to achieve there because it said you mustn't tax
Yes.
profits.
That comes back to the distinction between relying on a directive to nullify national law and relying on it as a source of rights. And what I'll come on to is that actually the analysis from the Court of Appeal and Lord Hope is that there has been some confusion. The phrases used, they shade into one another. That's why some of the case law sometimes can be interchangeable about that. But the principle is simply, I say, at paragraph 61, the basic point that the fact that a member state can choose among several possible means of using the law does not preclude the possibility of direct effect.
Yeah.
So having gone to Cobblefreight, if I could take your lordships back to Three Rivers, and this time on page 523.
So it's still the majority.
Yeah.
Yeah.
And at C, just under C, that paragraph there, which effectively says the same thing that Becker paragraph 25 says about the two types of ways you might rely on a directive. But then also in particular the second part in brackets about relying on EU law as giving a right to reparation, brackets in English law damages.
Right.
Yeah.
And just following on from that then at 523E, that paragraph there, there's an explanation there of the distinction between a Frankovich style claim and a Becker type claim. Obviously a Frankovich claim being a damages claim against the state for failing to implement.
But that's different again because there you're saying there's been a failure to implement and the state is liable. You're wanting something different.
Yes.
You want a right to sue the employer.
Yes, that's absolutely right. And I don't think the respondent would say we're bringing a Frankovich claim, but this all ties into my point, which is they are completely separate.
Yeah.
And my case has nothing to do with implementation, Frankovich, anything. It's just saying we're relying on the directive of the source of rights.
Frankovich claims were all based upon some very early case law. I think my Lord Justice Lewis remembers Schoppenstedt and the famous Schoppenstedt formula had to establish a sufficiently serious breach of a superior rule of law designed for the protection of the individual, and that then became rolled up in Frankovich claims, which were just pure damages against the state, not necessarily about failure to do something under the treaty, whether a directive or regulation or even a treaty obligation. Not necessarily, and directives were just a small subset of that, really, which have different criteria and conditions.
And one consequence of the distinction is at 526, just under F, about one practical implication between Becker-type liability and Frankovich is the identity of the defendant. Obviously, in this case, this isn't a claim against the UK, it's a claim against the student loans company as an emanation of the UK.
Yeah.
And then at the bottom of that 526, the paragraph next to H is really a summary then of what the parties' arguments have been and the main difference between the parties. And you'll see from the first line going on, the basic principles to be applied. The main difference is to whether a directive once transposed ceases to be the immediate source of rights. The majority then went on to analyse the position on that, going then over the page. And they go on particularly at 527G to look at whether there's a distinction between a legislative once and for all failure to implement and a continuing administrative act. And look at two cases, Headley Lomas and Norbrook.
Is that in the context of a Frankovich claim, though?
No, I say it's in the context of a Becker type claim.
Right, okay.
And the Headley Lomas case, you can see a summary of the facts there at H. The Ministry of Agriculture, Fisheries and Food, for a period of around 3 years, had refused to issue licences for the export to Spain of live animals for slaughter. And over the page on 528, you've got a summary of the Norbrook case, which was again the Ministry, MAFF, the Ministry of Agriculture, Fisheries and Food, requesting information about one of the ingredients in a medical product from the manufacturer.
So one-off administrative breaches,
I think
as opposed to systemic Frankovich type breaches.
I think they were characterised as continuing administrative acts. So in the Headley Lomas case, it was from a period of about 3 years, where MAFF MAF was refusing to issue licences. I have to say I'm not sure exactly how long the request for information was going on in Norbrook, but there was clearly some argument between the parties which leads to this analysis about whether there's a distinction with any meaning.
But then they were treated as Becker type cases.
They were, and then on page 529, just under E, Lord Justice Hurst, giving the majority judgment there, says why it's been necessary to refer to Norbrook, but talks about how actually it's an unusual and inconclusive case, and ultimately says that it doesn't displace the general Becker principle.
If you look at this case, there is no doubt that the substantive obligations, you must have suitable equipment, are incorporated into domestic law. That's fine. The question is, did the directive also require an individual to be able to bring a claim for compensation if an individual employer didn't do that? If that's required under the directive, then the United Kingdom hasn't implemented it. If it's not required, then it doesn't matter. So it still seems to me the key question is was the directive intended to achieve? Was it intended to achieve a system where the substantive requirements were put into national law, and it was up to the UK to decide should it be civil or criminal? Or did the directive require the rights it defined and conferred were meant to be rights to compensation on the part of an individual employee against an individual employer if there was a failure to provide the relevant equipment? That still seems to be the ultimate issue.
Well,
Do you disagree?
no, I don't, and I can address you on that. I will try to hurry up a little bit in terms of getting there. There are just a few points of the judgment I would like to take you to.
No, please take your own course, because we want you to track it through in the way that we asked at the outset. Yes?
You've hit the curse of the court that's too interested.
No, well,
Which I suppose is better than the curse of the court that isn't interested at all.
exactly.
Which certainly, when I was in your shoes,
This is a
was
wonderful
kind of-
piece of
I can
archaeology that triggers all of our sort of atavistic interest in European law from years ago, you see. Very dangerous.
Well,
Yes. Anyway,
no, thank you.
try to focus. Don't get distracted by us, is what we're trying to say.
No,
Where do you want to go next?
yes. Well, Lord, if you look, just to look at then the methodology the majority used, I've taken you to various parts of their analysis.
Yeah.
At 530B, you've then got the heading, did the directive of 1977 confer rights? And that's where they then actually go on to start looking at the directive. So they've set out the framework,
Yes.
they're now applying the framework.
Yes.
I'm not going to go through that application because I'm going to come back to that in terms of what Lord Hope said, if I may.
Yeah.
Okay.
But in terms of my point, the majority's approach is the framework is not talk about implement, not implement. It's look at the Becker conditions. Are the Becker conditions satisfied? And that's what they then went on to do. They found the reason for the difference between them and Lord Justice Holt. The majority thought no on the facts of that directive. Lord Justice Holt thought yes. But on the framework, there was no disagreement.
Thank you.
I'll then come on just to Lord Justice Holt's judgment.
Yes.
We've got starting on 557.
557.
557.
Yep.
Next to E, we've got the heading then about the community law claim. There's obviously some overlap in many respects, but we've got, just touching on it briefly, at H at the bottom, the reference there to Becker, paragraph 24, but then also paragraph 25, which is again going over the page, that distinction between relying on it to nullify and relying on it as a source of rights. We've then got it on 558, just below A, that second, third line, that paragraph, talking there about whichever of the purposes, obviously their reference to the Becker conditions, whichever version, whichever way you use it, it's got to be unconditional price, and those same 3 points. The first is the identity of the persons entitled. The second is the content of the rights, and the third is the identity of the person against whom the right may be asserted. So those are the 3 Becker conditions.
And defensive or aggressive simply means, as in Becker, I think she used it defensively because they wanted tax, and she said, my defence is you're not entitled to it. That would be a defensive use. Aggressive is they've taken my tax, I'll have it back, plus loss of interest.
That may be right, or also I think defensive would be I'm looking to nullify, if it was used against you, I'm looking to nullify an incompatible provision.
Well, or you could do it aggressively for a declaration of incompatibility.
Absolutely.
Yeah.
But it clearly covers all of those.
Exactly, yeah. You using private license, sword or shield effect.
Yes,
But
exactly.
again, you see, there could be different cases. Think about somebody who's an EU national wanted to come and work here.
Yes.
What they would want to do is be allowed to come in. They wouldn't necessarily, and they'd have a right to come in under the relevant provisions in place at the time. They wouldn't necessarily and automatically have a right to compensation in damages for the 2 weeks when they weren't able to work because they were still trying to persuade the people in the Garden Law to let them cross the channel. You do have to differentiate between the rights intended to be created
Yes.
and what follows in terms of what can the individual get. If it's a right to enter, he gets a right to enter. If it's a right to enter, he may or may not get compensation. That all depends.
My answer to that, I think, has to be that on the merits of any set of facts, you look at the relevant directive, you apply the 3 Becker conditions, and on any set of facts, if the Becker conditions are met, you are entitled to reparation. If they're not met, then you're not entitled.
But I think you're both right. That begs the question as to the scope of the directive.
Yes.
If it's clear, precise, and unconditional, and all it gives you is a declaration that the public authorities have failed, that's one thing. If it's clear, precise, and conditional, and says you have a right, and we infer that it's a right for an individual, which can only really be remedied through individual rights, then it may go to civil remedies.
Yes, and that's again going back to 523C, what Lord Justice has said. In English law, reparation means damages.
Yes.
I think what you're saying is that direct effect is not simply the mechanism by which it's enforceable in a domestic court. You're really saying, I think, if it's something that affects what an individual is supposed to have, any financial loss stemming from not having that thing must be relatable in English law. That's
Yes.
what I think you're saying.
Yes. If there's any directive that confers rights on a class of people, and I as a claimant fall within that class of people, and I can show that the obligations are sufficiently clear, and I can show the identity of the defendant, I meet the 3 Becker conditions, and I can then get reparation for my for the state or the emanation of the state's failure to observe my rights. And Lord Justice Hurst says in English law that's damages. In terms of just continuing through the judgment, we've got ticket 592. The section that's marked out by G, having analysed the principles, Lord Justice Old ultimately says it does not follow from that starting point non or misimplementation should be regarded as a precondition. That's the clearest part of the judgment there, saying as much.
Sorry, 592 at G,
Yes,
citing from Steiner.
yes. And then over the page, still the same marked up passage at B, in my view, therefore, non or misimplementation is a reason for giving a direct effect. It should not be a condition. And then on page 594, starting I think at B really, again reference to Steiner, talking there about whether a directive has been correctly implemented, only assessed by reference to the directive itself. But then continuing clearly as a result of the court, European court's ready application Frankovich principle, the 2 approaches can shade into one another. So that's the Becker type liability and the Frankovich type liability. But then whichever route is taken, the answer should be the same. So those were the 2 then judgments from the Court of Appeal on, if I can call it, the framework. And they both agree, both judgments, that non-implementation isn't a precondition. They both then go on to consider the directive, which is what I'll come on in a little bit to do in our case. But those were the judgments in the Court of Appeal. And then if I could take your lordships to Lord Hope's judgment, which starts at 655. And then just below D, near the very start of the judgment, we've got heading community law. That's then the passage I've taken your lordship.
I'm sorry, page number again.
655.
Thank you.
So that passage there and then over the page is what I've taken you to previously, where it gives a summary of what the plaintiffs in that case were saying. But then over the page, a little bit further down next to F, we've got the heading of conditions of liability. Lord Hope recorded that there was no real dispute between the parties in the course of the arguments before the House of Lords. He then refers to both the majority and dissenting judgments in the Court of Appeal, which he said dealt with the matter in great detail and with admirable clarity. But he then goes on next to G to say, nevertheless, I think it's necessary for me to explain the criteria which must be fulfilled. What Lord Hope is saying there is, I am going to go on to say what is the legal framework for analysing whether you can rely on direct effect. He then continues to do that. Over the page on 657, he himself quotes the same paragraphs from Becker, the quote starting next to E. We've got the same paragraphs 22 and 25 in particular. And again at H, he flags up the same point about this distinction. What the Court of Appeal describes as Becker-type liability, the rights must be, over the page, unconditional, sufficiently precise. And then that distinction, which is between relying on a directive to nullify and relying on a source of rights. In that case, the plaintiffs had sought to do both. At 658H then at the bottom, he mentions the case of Dillencoffer, where, as Lord Hope says, the court restated the conditions for state liability in light of the number of cases which it had dealt with subsequently to Frankovich. And then over the page on 659, he cites from Dillencoffer, and particularly next to F, paragraph 22, which refers to Frankovich. I'll come back to what Lord Hope says about that. But that sets out its own similar modified Becker three-stage test. There must be a grant of rights to individuals. The content of those rights is identifiable on the basis of the provisions of the directive. And then 3, a causal link exists between breach of state's obligation. In our case, I'll say we're talking about the emanation of the state, not the state, and the loss or damage suffered. So that's the Dillencoffer conditions as opposed to the Frankovich conditions.
I thought Dillencoffer was a Frankovich case.
It was. Lord Hope goes on, I can take you straight to that, to say that although it's a Frankovich case, he thinks those conditions are clearer and more precise, so he's using those. He says that, my lord, sorry, let me just jump ahead slightly. At 677, next to C, so this is later having analysed, I'll jump back a bit in a minute, but subject to the qualification that I have submitted the Frankovich test as applied in Dillencoffer for the Becker test, on the view it is more precise and covers both types of liability, by which he means Becker type liability and Frankovich type liability. So Lord Hope then applied the Dillencoffer para 22 rather than the Frankovich, the Becker conditions. But just jumping back a little in the judgment, as Lord Hope continues to go through at page 660, 660, next to C, just above C, you'll see he's talking about Lord Justice Old. In the course of the development at this point, he gave 2 further reasons for rejecting the bank's arguments that implementation of the directive deprived claimants of recourse under Becker-type principle of liability. Lord Hope says to which, in my view, great weight should be attached. In that same paragraph towards the end, He says, I think that Lord Justice Old's observations are worth recording here in order to set the scene for an examination of the directive. And then he goes on to do that. Next to E, for my part, I think the second point is most relevant. Next to E, his second point was that the recent decisions of the European Court, including Northborough, indicate in the main the court is indifferent to the precise route by which it gives effect to a directive. And then, as you see at the bottom of the page, he goes on to cite from Steiner. And then over the page at 661, next to B, he says, in the result, although the appellant's case under community law is put in different ways and based on both types of liability, i.e. Becker and Franklin, the conditions which the plaintiffs must satisfy in order to establish a right to damages against the bank under each route is so closely analogous that they can capably at this stage of the case the same. And then he goes on to say, the critical questions in this appeal following the language of para 22 of the judgment in Dillon conduct. And that's the point I'm taking you to later in the judgment where he says, I've substituted Dillon because I think it's more clear and precise.
And just looking at the last lines of B,
Yes.
the critical question is whether the directive, and then we really just, we interpolate, properly interpreted, confers the grant of rights to individual depositors and potential depositors, and also whether the content of the rights is identified on the basis of provisions of the directive. So we go back to the directive, we look at their provisions, and we ask what sort of rights are intended to be conferred on individuals as a matter of interpretation and construction.
Yes, that's right. And just on that point, you'll see just below that passage, of course, then the next section starts with the heading, the legislative base and purpose of the Directive 1977. So what this is his conclusion on this is the framework. Now I go on to consider that the directive under that framework. And so at the end of his setting out of the legal framework, that is the point when your lordship says the critical questions are these. That's him saying this is the framework. Now I'm going to apply it.
Yeah.
So on that point, in terms of Three Rivers and what is the ratio of the case, and for our purposes, what is relevant, one of the key points from Three Rivers is I say that on the face of Lord Hope's judgment, the ratio of the decision is implementation is not a precondition. The Becker or the Dillon-Coffer conditions are the test that you apply. That has to be clear, I say, on the Lord Hope's judgment. If it's not, and this is why I described it earlier, it might be an abundance of caution point, but given that Lord Hope earlier in the judgment says there was not as much argument before your lordships between the parties as there had been before the Court of Appeal, this is why in the bundle we've included the case of Qadim at tab 8. And
Tab 8 and
tab 8 of authorities.
do you want us to go there?
Yes, please.
This is back in the other one. Any
Tab 8 at 359. And the head note there gives a fairly comprehensive summary, but the facts at Qadim were about the housing benefit general regulations. The claimant in that case lived with his landlord, who was also his brother, and he shared a bathroom, he shared a kitchen, shared a living room, and before the Benefits Review Board, which he then judicially reviewed, the question was whether the regulations prescribed a complete test for residence, so that because he lived with a close family member, he didn't qualify for housing benefits.
Just whether, as to whether Qadim applies, I'm just going back to what Lord Hope said on page 656. He starts by saying there's no real dispute between the parties. And then he says, the judgment of old deals with the matter in detail and clarity. Then nevertheless, I think it's necessary for me to explain at the outset the criteria which must be fulfilled. So he's given mandatory guidance, yes. And his judgment was adhered to by his colleagues. Is this really a case of something not having been dealt with?
Well, I say that my primary cases it has been dealt with, and perhaps it is an abundance of caution, but it's only a short point, so it won't take up much of your lordship's time.
Yeah.
There are two really passages in Qadim. The first is on page 365, So in that case, there was a case of goonery where the judge had held himself to be bound, and there was an analysis then of what was the ratio of that case and does it bind in any event. Paragraph 16 on 365 is simply a concise statement of the fundamental principle of what is the ratio of a case, which is any rule of law expressly or impliedly treated by the judge as a necessary step. I don't think that would be controversial, but what is then more particularly relevant is over the page on 366. We've got the heading assumption without argument. And I've marked up the whole thing, but particularly paragraph 21, Court of Appeal there, saying there may be a number of ways in which propositions that have not been subject to argument become ratio. But what is relevant for our purposes
I know why you're taking to it. I mean, I'm just looking at 660C. All that Lord Hope says is the submission didn't receive the same prominence
yes.
before their lordships, though he then goes on to discuss what Mr. Lassock then argued at some length on this point. So, anyway, we understand why you're taking us to it.
My only brief point, apologies, I've taken you then to the wrong page. On 369 in the Kadim, from 33 onwards, it's simply saying, we conclude not without some hesitation there is a principle that the subsequent court is not bound by propositions law assumed. But then what is really relevant for our purposes is the next paragraph and onwards. And then, apologies, particularly 38 over the page, which is that like all exceptions and modifications of the strict rule of precedent rule must only be applied in the most obvious of cases limited with great care. And then continuing on in the paragraph next to B, there may be, of course, cases, perhaps many, where the point has not been subject to argument, but scrutiny of the judgment indicates the court's acceptance went beyond mere assumption. Very little is likely to be required to draw that conclusion.
So just to be absolutely clear, so joining up the dots, if Lord Hope's judgment is not binding on us, the position is we are bound then by the Court of Appeal, although you, in fact, you say they say the same thing. Is that what you're getting us to do?
I'm saying Lord Hope's decision is binding, primarily on the basis of, if you look at the judgment on its merits, it's clear what it's binding.
And you're taking us to Kadim and so on the assumption that it's not binding.
As a fallback to say it is binding, but only, and this, as I say, may be unduly cautious, simply because he says the argument did not receive the same prominence.
And if we come to the conclusion that there was an assumption, not a full debate and discussion, is the next logical step that you're saying we're bound by the Court of Appeal? That's what I was getting to.
No, my position is Kadim says it's a very low threshold to find that the court did go beyond mere assumption. It is clear that Lord Hope did very much go beyond mere assumption, because he was at great pains to recite what the Court of Appeal had said, referred to it being dealt with great in detail and admirable clarity.
So it's another reason for saying we're bound by Lord Hope.
Yes.
Your fallback position is not that we're bound by somebody else. Your fallback position is we're still bound by Lord Hope, but because it's a very low threshold.
Yes, I'm saying read Lord Hope's judgment. It's clear what he's finding. If there is a question mark over, did he make that with the benefit of full argument? Kadim says it's a very low threshold to find he just did more than assume, and he clearly did do more than assume, because he recites those passages.
He doesn't say they didn't receive full argument, he simply says there wasn't the same extent of the argument.
No, exactly, and that point obviously would support my case, and it may be that this is, as I say, just an overly cautious approach, but that's my fallback.
Understand, thank you.
So the ratio then, ultimately, I say, of Three Rivers, is that the question of implementation is not a precondition. You look at the Becker or the Dillon-Coffer conditions. My primary submissions today are going to be on the basis of the Dillon-Coffer conditions, simply because that is what Lord Hope at 677C had said. He he was substituting for the better test.
Just take us back to that for my part.
Yes.
That
661.
677, did you say?
661, isn't it?
Yes, so 677C was where he said, I've substituted the Dillon-Cropper test.
Yes.
And then the Dillon-Cropper test itself, 659 and F is a useful
Yes.
paragraph 22, then that is actually the test.
Yeah, and then doesn't he say that really at 661, the critical question in this appeal, following the language of paragraph 22, is whether that particular directive property entails the grant of rights to those particular groups and whether the contents of those rights is identifiable. That's the key test, you say, isn't it?
That's it, that is actually, yes, absolutely. And that's what I'll address you on now in terms of this directive.
Right.
And then the
As a
directive-
grant. Now, how would you phrase the question using Lord Hope's language in 661B, the passage my Lord's taken you to?
Yes.
How would you precisely word the question in this case?
The first then limb, the first condition is there a grant of rights to individuals?
to individual employees.
Yes, that is my point. If you look at the directive, if we go back
Okay, so would you mind just phrasing the question for us precisely?
yes,
Because obviously, Lord Hope talks about individual depositors and potential depositors. How would you phrase the question precisely in respect of the directive we're concerned with?
does the Work Equipment Directive entail a grant of rights to workers?
As simple as that.
Yes.
Thank you. Now, to go back to the directive now.
Yes, please. Tab 2, page 18.
Yeah.
And back to recital 6. You've got there about compliance with minimum requirements. And the end of that recital, essentially in order to ensure the safety and health of workers. So that is where the individual, if they fall within the class of a worker, that's where their rights derive.
This is probably the most difficult part of the case, but 3 years to encourage improvements of the working environment so as to protect workers' health and safety. And 6 explains why safe use of work equipment is essential to safety and health. So one of the purposes, or a purpose, is to protect the health and safety of workers.
Yes. And I would say it needn't even be the only purpose of a directive.
Yeah.
If there is a directive that gives a class of individuals a rights, then that's the end of it.
Is it to encourage health and safety or to guarantee health and safety? Or does it not matter?
It's to ensure in recital 6. It's to ensure the safety and health of workers. So it's an absolute term.
And that's reflected in Article 3,
Absolutely, yes.
which is that the employer shall take the measures necessary to ensure
Absolutely.
that the equipment is suitable.
Yes, and on that point in Article 3 that's on page 19, again, in terms of identifying the individuals, again, it's workers. You've got there, as my Lord Justice Green says, the wording of Article 3, it's made available to workers and used by workers without
And the caveat in 3.2 is where that's not possible, then there is a secondary duty to minimise risks.
Yes,
It's not just an obligation on employers which the state can enforce by one way or the other. It's an obligation on employers and a correlative right on employees to receive that which the employers should be doing.
yes. If the respondent is an emanation of the state, and we meet the Becker conditions of which the Dillon-Coffer conditions of which this is the first, then this is a step in the chain of saying we can rely on the directive.
Yeah. The
as
key
it says,
question
right.
is whether it gives rights to employees or whether it imposes obligations on employers, which the state police. If it imposes obligations on the employers, it's for the state to decide how to police. But you're saying it goes further. It's not simply employers must do things and the state must make sure they do them. It's further than that. It's the employers must do things and the individuals have rights.
Yes, to answer that, there may be some overlap there at this point between condition 1 of Dillon-Coffer, which is the grant of rights to individuals, and then within Dillon-Coffer condition 2, which is the content of those rights is identifiable on the basis of the provisions of the directive.
Okay, so I asked you what the question we had to answer was.
Yes.
Applying Dillon-Coffer, and you said it was, does the directive entail the grant of rights to workers?
Yes.
Is that now it seems to me saying there's another question.
No, that I'm to answer my Lord Justice Lewis's question. I say that goes to one of the later conditions. In Dillon-Coffer, it might be a bit harder to identify, but in the Becker conditions, the third Becker condition is the identity of the person liable to provide the guarantee. So that would answer that question of you've got the individual entitled to the rights of the worker, you've got the identifiable, the identity of the person liable to provide, that's the employer.
I understand that, but that's not my concern. My concern is a deeper one. I think this is a difficult question. The question is, was the purpose of this to create regulatory obligations on employers to be policed by the state? Or was it, just as the third Free Rivers case, to confer rights on depositors? It was not just to impose obligations on employers, which can be policed in a number of ways. It was actually intended to give enforceable rights to individuals to make sure that their employees did it. So if they didn't do it, they could get compensation. So for example, they could go and get an injunction telling him, give me a proper working earpiece.
Yes.
And or damages for any loss he suffered.
Yes.
That's the question, is whether it is intended to enable the employees to have such rights.
But that's where, again, going back to the beginning of my submissions, my position is that is the wrong way around to look at it.
I know, but if you're not right on that.
Well, my answer to that would be, I'm still dealing with that question rather than what's the alternative, but my answer to that is, you go back to what's said by Lord Justice Hurst at 523C, you've got a right of reparations under a directive, and that those reparations in English law means damages. It's not a Frankovich type question of damages for failure to implement. It's not a breach of the principle of equivalence, that less favourable, therefore damages. It's just saying, I get reparation, and in a different country that might mean something else, but in the UK that means damage.
Where do you get the right of the workers to compensation from the wording of Article 3.1, which is worded as imposing obligations on the employer? Shall is suitable.
It's not the right of compensation to the workers. So that, going back to the cobble freight passage I referred to earlier, and what was Article 189, we're not saying, and everybody's always understood, that member states have a discretion on what implementing measures they put in place. Our position is simply, and therefore it's a misnomer to look at the wording of Article 3 in terms of what are your rights, do you have a right to damage? The right is simply, you have a right as a worker to be given work equipment which is suitable. If you are not given work equipment which is suitable by an emanation of the state, and the 3 Becker conditions or Dillon-Coffer conditions are met, you are entitled to reparations.
We don't have to identify the right to damages. We have
right,
to,
okay.
it's a right which is personal, if you
To
like,
the employee, yes.
to the employee.
So you have a right to be work equipment that's suitable.
You would say it was 3 things. It's the mandatory duty on the employer, which is owed to workers. That's the second line. That the duty owed to workers is that it is suitable, and fourthly, may be used by the worker. So it's a duty on the employer directed to the preservation of the employee.
Yeah.
And your case would be that sufficiently personal to then trigger an EU right, which, if it applies, would include a right to damages.
Absolutely.
or an injunction. It doesn't matter what
Or
the
an
point is.
injunction.
It's the workers. It's not something the employer must do in the abstract. It's something that the directive wants the employee to be able to police himself.
Precisely.
Yeah.
It is as simple as saying you don't get into damages injunction remedy. You say the right under the directive is the right to be given suitable work equipment. There are the other stages I'll come on to in a moment, but that is the right. The question of reparation, how are your rights vindicated? That's a separate question.
But before Becker, what used to be three conditions was clear, precise, and unconditional in terms of conferring rights on the individual. And those latter words sort of evaporated as the case law evolved. But it was always about identifying whether the legislature was trying to protect an individual.
Yes.
And you get a cascade, you get obligations on the state to do structural things, finance things. But then when you work down the hierarchy and you focus on the individual, then it is more likely that you would have a directly effective right. And your position here is when you look at the wording of 3.1, coupled to 3.2, it is focused upon the protection of an individual right. And the duty is imposed on the employer, but it is for the protection of the individual.
Yes, exactly. An individual who falls within the class of a worker who's been given work equipment has the right for that work equipment to be suitable. It's a simple.
But that's the issue, I think, between you is how we interpret what recital 6 and 3. And you say the fact it's minimum or this discretion doesn't disqualify direct effect from applicability. We now focus really, as we said right at the outset, it's a difficult question of construction. What does the directive impose and how granular is it in relation to the protection of an individual?
Yes. On that, obviously, you've heard my primary point, which is the right to be given work equipment which is suitable. You've heard that. I would say, in terms of what the respondent might say or what the arguments might be to the contrary, I would ask your lordships to consider that nowhere in Three Rivers, Court of Appeal or House of Lords, do the judgments analyse or rely on any question of what is the remedy. It is just Becker-type liability morphed into Dillon Coffer following Lord Hope.
The English equivalent is breach of statutory duty. You just look at the statute and you ask, is it intended to confer a right upon an individual? In which case, the tort then jumps in and says, here are your suite of remedies for that statutory duty.
Yes.
You don't find the remedies in the statute. You find them in the general common law of tort. They're outside of it. And direct effect is, you go back to in House of Lords, was it Garden Cottage Foods 40 years ago, they said it was the breach of statutory duty. I don't think they were right. Direct effect is direct effect, but that's why we don't look for a remedy in the measure. We just look for the nature of the obligation imposed.
Yes. Yes.
Do we get any help from Article 4? It says without prejudice to Article 3, it's all about work equipment. And then it sets out things that the employer should do, i.e. they've got to get work equipment which meets certain standards. And then you get to 3, which seems to be what the member state is required under the directive to bring about as a result in relation to Article 4. Shall, with due allowance to national legislation, establish procedures whereby a level of safety may be attained corresponding to the objectives indicated by Annex 2. So when you're looking at, you've got the purpose, you say, is to protect workers, you've got the language, duty on employees, but owed to workers. But then I'm looking at Article 4 and I'm just wondering, this is the detailed code, and when you get to how that's intended to be policed, if that's an additional thing, member states must establish procedures, but it doesn't mean there's no right owed to the workers as well. Or does it mean it's building up to really, at the end of the day, this is not the conferment of individual rights on employees, it's to do with making employers do their bit properly. Do you see where I'm coming from?
I do, and I hope this will address that head on. At this point, perhaps it's useful to go to the Hyde and Steeplechase case in the authorities bundle at tab 5.
That wouldn't help, because if we were in Sweden, they'd never have heard of Hyde and Steeple. I think it is the point about the directive. It's best to do it by reference to principles first, and then certainly take us to Hyde afterwards. But if it is Germany, as I said, or Sweden, they wouldn't know anything about Hyde. So what's the principle from the interpretation of the directive?
Simply that The regulation 4 of the provision and use of work equipment regulations is based on Article 3 of the directive. And both sides have agreed, and it's in the respondent skeleton, that the regulations faithfully transpose the directive. So that's the like for like. Whatever another part of the directive might say, I accept if it casts light on something else, it's obviously relevant. But ultimately, we are saying we are entitled to rely on Article 3 of the Work Equipment Directive.
And that's without prejudice to Article 3.
Yes. So that Article 4 may deal with something that isn't caught by Article 3, but we are saying, on our case, we were provided with work equipment that wasn't suitable. We might not have a civil remedy anymore under the regulations, but we're relying on the directive. That is as simple as that. So any point about Article 4, which is without prejudice to Article 3 and doesn't cast any light on the recitals or Article 3 itself, just is perhaps for a different case, but it doesn't take us any further. That's one.
The annexes concern things like fork trucks, lifting equipment and so on. Is there anything very particular in those which relates to noise abatement equipment around the ears?
I haven't seen anything like that. Even if there were, I should say, I haven't seen, but again, the principle is still different. Even if the directive said everyone that's given a headset will be given this model of headset or will be signed off as complying with this, that still is separate. Obviously, it's a question of what is your remedy. And I know I've made that point a number of
We
times.
understand that, but we moved on from there. We are not looking at whether it gives a remedy.
Yes.
We're looking at what is the person to whom the directive gives the right. Is the person imposing an obligation of the employer, or is the directive giving a right to an employee? And I was wondering whether Article 4 did or didn't help us in working out the answer to that question. Is it about imposing obligations on employers, full stop, or is it about doing that but also giving rights to workers?
My position from the recitals, particularly recital 6 and Article 3, is simply for our purposes, it is, and again applying the Dillon-Coffer test, a grant of rights to individuals.
But are they the workers?
Yes. And that's why when my Lord Justice Baker had asked me to frame the question, that's how I'm framing it. Does the Work Equipment Directive give rights to workers? And that's my position, that it does, and condition 1 of Dillon-Coffer is satisfied.
Yeah.
Condition 2 of Dillon-Coffer then is that the contents of the rights are identifiable on the basis of the directive, which I think perhaps touches on the points we've been discussing, which is, I say they are. Article 3 on page 19 says you must ensure the work equipment is suitable. So that's the content of the rights. Again, the right is a worker has the right to be given work equipment which is suitable. And on that point, given that the Regulation 4 of the Provision and Use of Work Equipment Regulations, it's agreed by both sides, faithfully transposed the directive, it would be difficult to define to the contrary, I say, because if Regulation 4 clearly identifies what the rights are, it's hard to say that Article 3 doesn't. And it is as simple as saying content of the rights is not to be provided with work equipment unless it's suitable.
Article 4 is without prejudice to Article 3. If Article 3 confers rights, 4 wouldn't take them away. If it doesn't, 4 won't grant them.
No, sorry, my mistake. Regulation 4 of the implementing regulations are what implemented Article 3 of the directive. And my position is simply when you're looking at Article 3 on its merits, if you were positing, well, in what way might the rights not be identified, it's another factor that militates against finding that to say, well, actually, can we really say they're not identifiable, given that for years and years everybody's been applying Regulation 4 of the regulations, and no one is saying that that was unclear or nobody knew what it meant. The third then Dillon-Coffer condition is that a causal link exists between breach of the state's obligation and the loss or damage. Again, obviously our claim is not against the state, it is against the respondent as an emanation of the state. The respondent's breach of the obligation was, on our case, provided work equipment that wasn't suitable. And in terms of the causal link, in Three Rivers, it was said in the Court of Appeal, summarising some case law, that that's simply a matter to be determined by the English court under English law. That's at page 595, so tab 13 in Three Rivers, page 595.
That's another way of saying it's simply the question of fact which would be determined at trial.
Exactly. Claimant's case is I suffered an injury because of work. So for my part, the third condition is as straightforward as that. So obviously, if Claimant couldn't prove causation, he'd be in trouble, but his case is can, and it's normal rules of English law.
But that's not something we have to grapple with. If you're right on the appeal, that will be determined either in your favour or against you.
Yes, and it had occurred to me, jumping ahead a little bit now, but would the court remit it or deal with it itself? I would be saying if we got there, it's such a narrow, discrete point, you've got the medical report, rather than remit it, which would be disproportionate, the court would simply deal with that itself. But I'm not saying that's the only option. Obviously, it could be remitted to the trial judge.
On the question of facts,
Yes.
has it been resolved that the equipment was not suitable, is the first question. And then secondly, has it been resolved that the thing that caused the tinnitus was the faulty equipment?
No, and I can accept those would obviously be good reasons actually to remit. It hasn't. Effectively the claim was dismissed at trial on the basis of we accepted our only claim was direct effect under the directive.
No, we've seen the judgment.
Yes.
It's not determined. As a matter of fact, if A, it was or wasn't unsuitable, and B, if it was unsuitable, whether it caused the tinnitus.
Yes. Yes.
So that's got to be tried anyway if it win.
Yes. I've dealt with Dillencoffer, and as I said, my primary case is Dillencoffer because Lord Hope says as such. It treads much of the same grounds. If I may, I am just going to then deal with the three Becker conditions just for completeness. The Becker conditions were, as I said before, one of the citations is in Three Rivers at tab 13 at page 658 of D. But taking those in turn.
So you're looking at the better conditions,
Yes.
are you? Not
yes.
the Dillencoffer now.
No, so
This
again,
is your
it
alternative.
might be an overabundance of caution, but my primary case is Dillencoffer because that's what Lord Hope says. In some set of circumstances, if your lordship's thought actually you should be applying Becker, I'm just dealing with it quickly now as well.
And this is 659 at
659 is where Dillencoffer are.
yes.
22. 658 at D, is it? Is that the passage you were taking us to?
Yes.
As a sort of shorthand version of finding the Becker condition.
Yes.
Yeah.
Yeah.
The first statement, again, there's a lot of overlap. The identity of the persons entitled, well, again, that's workers for all the points I've made.
Yeah.
The content of the guarantee, well, again, that's the Article 3.1 ensure it's suitable for the points I've made. And then the identity of the person liable, well, again, Article 3.1 on page 19, it's under the heading of the employer's obligations, and it says the employer shall take the measures. So the identity of the person liable is the employer.
Yes. So that's not part of the, strictly speaking, part of the Dillencoffer 3, is it?
No, that's the difference really, is Dillencoffer 3 is the causal link, which I say actually doesn't add too much for our purposes.
On this
It's
case?
standard. Yes, on this case. And the Becker 3 is the identity of the person liable, which the answer
So those are the two discrete ones from the two tests.
Yeah.
In 40, the first condition is still the same thing. When it says entail the grant of rights to individuals, it still did the directive intend to grant rights to workers.
Yes,
It's that question has got to be answered.
yes, it does. And again, you've heard my submissions in a
It's the
nutshell.
same question, yeah.
It's not remedy, it's what are the rights.
And why don't, could it not be said that all four of the two that overlap and the two that don't
Yes.
all have to be satisfied. Is that not a reasonable way to proceed?
I can't really argue against that. I can see the sense of that, and it would be.
It doesn't affect you because
No, I'm not going to pick a hill to die on of saying you must not consider her. They all seem to me to be relevant, so I'm not arguing against.
I mean, if surely you'd have to establish, wouldn't you, that the person, the defendant or respondent in any action was a person liable to provide the guarantee.
Yes, and perhaps the overlap there might be under the Dillenkoffer second requirement, which is the content of those rights is identified.
We'd incorporate that.
That's the content of the right is my employer shall give me, and that's where they meet.
Yeah. So Dillenkoffer probably, on that interpretation, covers all three.
Yes.
We shall call it the Dillon-Becker test.
Yes.
Becker-Dillon.
Never mind. Okay, right. So we've I think that with a broad interpretation of the second condition in Dillenkoffer, it covers all bases in Becker.
Yes.
Anyway, it doesn't matter here, but you say on your case, it doesn't matter here because on any view, the way Article 3 is couched, an emanation from the state is covered. Right. How are we doing?
Just
12 o'clock.
we're doing well. Before I move on to ground two, just a couple of points, if I may. One may help in answering your lordship's questions about this difficult question about the extent of the rights. Back in Three Rivers at tab 13 on page 661,
Yeah.
with Lord Hope. At the risk of going over old ground, at B, talking there about the community law case put in the different ways under both types of liability, going back to what he said about the critical questions in the appeal, in that case, whether the directive of 1977 entails the grant of rights to individual depositors and potential depositors. So in that case, you had a directive that regulated credit authorities, and the plaintiffs were trying to go one stage further to say, because we're then ultimately the beneficiaries of that, or it's a three-way relationship, that we are also entitled to rights. But my point on this is that Lord Hope is looking at whether it entails the grant of rights to individual depositors and potential depositors. He is not saying, and do those rights require a civil law remedy?
No, we got that, yeah. Is there any, it's surprising in 2026, given that these directives have been around for ages, is there nothing, we were saying something yesterday on the European Court front, indicating what the European Court thinks is the depository of the rights, the people that have the rights?
We certainly couldn't find anything that is as simple as that. But there are, I would say, by inference, the answer is, again, they're looking at it in the way I'm advocating, which is, as in Becker, where, as the Court of Appeal noted, actually there was implementation, but Mrs. Becker nevertheless succeeded, or the Cobblefrate case about, even though there's a discretion for member states, the European Court that takes the approach I would suggest, which is ultimately then considered and applied in Three Rivers, of you're just looking at the right itself, not the remedy.
I think that's probably a different question, because there've always been arguments about what amount of discretion prevents it being directly effective, and the answer is you can have some discretion so long as it's confined and you've got criteria. So I'm not sure that helps. I was much more interested in knowing whether there's any judgment from the European Court that says the people who are intended to benefit from this were the workers. They have the rights, and it's for them to, it's for member states to ensure that those rights are protected. But you say there's nothing on that.
We certainly didn't find anything on that. There is analysis in Three Rivers of environmental cases relating to health, where it's said that it's not hard to see that individuals would benefit because public health, environment affects all of us. There's reference in Dillenkoffer.
Sorry, and in those cases, was that sufficient to give rise to rights or not?
It was. So the page reference for that one would be 668.
But a worker's position is much more acute, isn't it? In the sense that public health generally to community is one thing, but a worker's in a very specific position, you would say.
Yes, and this is obviously a specific directive.
And yes, it's a yeah.
So I would say it's hard to see, reading the words of the directive, what else the rights are intended to be, if not for a worker to be provided with work equipment which is suitable.
You could have turned the wording round in Article 3. Workers shall have from their employees suitable equipment, and it's exactly the same substance.
Yeah.
And then you say, well, of course, it's workers of the recipient. But the wording is neutral or in your favour, you say.
I do, and again, going back to the Becker conditions versus the Dillenkoffer, where you have this element of the identity of the person who's got those obligations, or in Becker, the content of the rights, which involves from the employer. Both sides of the coin are clear. The employers are under the obligation, and the employees are intended to benefit, or they have the right. The final point then I was just going to make before coming on to ground 2, and I appreciate I've skipped over ground 1 as well, although that might be a shorter point, but on ground 3 is just to flesh out a little bit what I said earlier, which is the respondent has got the wrong end of the stick when it's saying about the directive does not require a civil remedy. All of the respondent's authorities, to be clear, all of them are on the principles of equivalence and effectiveness, which is a completely separate question. As I've said, Three Rivers, for example, no analysis or reliance on those principles at all, because it's just a separate issue. Peterborough, for example, is a principles of equivalence and effectiveness case. Just in terms of page references, you've got page 948 of tab 24. You've got references there in the case to equivalence and effectiveness.
And we're not really into the area of equivalence, are we? Because if there's no need for the rights of workers to be protected, that's the end of it.
Yes, our position is if the respondent's an emanation of the state, our primary case then is we're entitled under Becker/Dillenkoffer to rely on the directive and get reparations, which means that questions of implementation equivalence don't arise. Obviously, if the court then finds that it is that we do have to show a failure to implement, then we come on to ground 2.
But say it's a different failure, because we don't agree with your analysis. Say the failure is that it wasn't intended to give rights to workers, it was only intended to pose obligations on employers.
Yes.
Does equivalence help you then?
It does. But can I, I think I will. I don't need to take your lordship through all of the passages in the respondent's cases which refer to equivalence and effectiveness. They all do. So if I jump ahead to that, my lord, it does help us. If I can perhaps just set out my stall on ground 2, that will help answer the question. A helpful summary of equivalence effectiveness is in at tab 15, and I think it was a Spanish claimant, and it's pronounced Ayarte. Sorry if I said that wrong.
Tab 15.
Tab 15.
Oh, okay.
Yeah.
I would call it Cheshire County Council if I were you.
I don't know why I hadn't thought of that one. I appreciate that. In Cheshire County Council, you've got from the judgment of Lord Justice Buxton at paragraph 47, the Commission there taking the text from the Unibet case, and the first paragraph then that's quoted from Unibet at paragraph 32. As you read down until you get about 7 or 8 lines down, you've got it's for the domestic legal system to determine the procedural conditions, provided those conditions are not less favourable than similar actions of a domestic nature actions, and do not make it impossible in practice, which is effectiveness, which I'm not arguing. I know. So that's just a summary quickly of what the principle of equivalence is. On that point, and I realise my lord's also asked it in terms of the wording of the directive, but just to make clear on this, because it will involve taking a comparator. Our position is to look in domestic law and community law at what is a claimant's position if they've been injured by work equipment. If they say that work equipment's not suitable or doesn't meet standards of reasonable care. Before October 2013, they had at least two options available. One is a civil law claim for damages, and then the second is to pursue themselves or through the HSE or anybody else criminal remedy. That was the position in domestic law, common law negligence or criminal remedy, and it was also the position in community law, because they had, in our case, Regulation 4 of the provision and use of work equipment regulations, and also any criminal remedy.
Post 2013, there's no civil liability for
Yes.
breach of the regulation. So the most directly analogous one doesn't have a civil remedy. So I come back to two questions. If workers are not given rights at all, does the question of equivalence arise? But secondly, if workers do have rights, what are you comparing the workers' rights under the directive with under English law?
The way the comparison is done for the principle of equivalence is to look at similar actions of a domestic nature.
So start with the first question. I've asked two. If there's no right conferred on workers, I know it's not your case,
Yes.
but if there's no right conferred on workers and we go AWOL and we decide that, is that the end of equivalence?
No, because there was an EU derived right under the regulation, and there still is to this day. Of course, the difference is remedy, because there is an EU derived right in the form of regulations. You have to then compare the remedies available under that with a similar action of a domestic.
So
nature.
there's a regulation that gives workers a right? A domestic regulation that gives workers a right. Is that what you're saying?
Yes, Regulation 4 is really the same as Article 3. It entitles workers to be provided with work equipment which is suitable.
Have we got that? Did we bring it?
We do, yes. So it will be the tab just after the directive. It's tab 3. And then Regulation 4 is page 36.
Right.
So that's an obligation on an employer to do certain things. It begs the same question. Is it a right owed to employees? There's no civil right on employees. They can't bring a claim, can they?
Not anymore. So they
Yeah.
used to be able to under the health and safety
Yeah,
work.
but that's gone now.
No,
That was the abolition of Section
In
47.
historic things. I'm looking at it today.
Yes.
So there's an obligation on an employer, but there's no corresponding right or actionable duty given to employee.
Yes, so the employer is still under an obligation, and if they breach that obligation, they might, for example, be liable for criminal penalties.
Yeah.
But
So
there's no.
does this help us with equivalence? Does Regulation 4 help us with equivalence then?
Yes, it does, because this is the community law part of the comparison. Regulation 4 is the community derived law. Regulation 4 implements Article 3.
Yeah.
That's community law, and you compare that with a similar action of domestic nature.
Yeah. Perhaps I'm just confused.
The
The assumption here is that EU law doesn't confer rights, that you've lost. There's an assumption.
Yes.
And there's no right conferred on workers. There's an obligation on employers, but there's no right on workers. And Regulation 4 means the same. No right on workers, an obligation on employers. I know you don't agree with that, but if that is the position, I'm still struggling then to see how equivalence works. That's my
You've still, in those circumstances, got negligence,
Yes.
tortious negligence, and you can still make a complaint of a criminal nature. I mean, I know that's not a private law
Yes.
right, but there are two regulatory mechanisms in tort and statute for
Yes.
enforcement of the duty on the worker on that premise. Which,
Yes, and
which
that-
is your what are we comparing with then?
Well, just to be clear on that, sorry, that why we're not arguing principle of effectiveness. We're not saying that it's practically impossible for our rights to be vindicated. Just to be clear, that's why we're not saying.
Yes.
But in terms of equivalence, it's looking at like for like. It's taking the comparison, which is the community law. Which
Well,
is,
that's what I'm doing. Could you put in one box the right, tell me who has it and where they get it from, and then tell me what the equivalent English law right is?
yes. So previously it was the directive. I think for our purposes now it will be the regulation.
So who has the right and what right is it?
On the premise, of course, the employee doesn't have the right.
Yes, that's the point.
So there's a duty on the employer,
Yes.
no correlative right on the employee on this premise.
Yes.
It's an alternative, you know.
Yes.
And in those circumstances, what are we comparing with what to determine equivalence? Because community law doesn't give you any rights at all on this hypothesis.
I think it comes back to ultimately I'm disagreeing on the prior point, which is
We-
obviously if
If you win on
lordship-
that, you're home. If you don't win on that, the question is, do you still get home?
I mean, I think I have to. I would have to accept, obviously, if you found that full stop, the directive absolutely gave zero right to any kind of civil. I just have to. It might be, if I may, I might park it and just reflect on it and deal with it briefly in a reply later. But I think it would be difficult if your lordships found that. But obviously, my point is that would be going AWOL, to use my Lord
No,
Justice
we understand that,
Lewis's.
but I think we're saying equivalence assumes you have a right, and you're looking at the right A as against right B to make sure they are comparable and on a par. But you're assuming the simpliciter existence of two rights when there is no right under EU law at all. Then we're wondering how equivalence, which is a relative concept, operates.
But again, I appreciate since the prior point, but going back to the Cheshire County Council case, it is for member states to determine the procedural conditions, which includes, I would say, is it a civil remedy or not?
If there's a right, yes. So you're always going back, I think, to your first
But
point.
I would say it's working backwards from that. If the principle of equivalence says it is for a member state to determine the procedural conditions, i.e. the right.
Procedural conditions for enforcing a right. If there's no right, procedures become irrelevant.
Rebecca talks about you've got to determine the content of the right, which is then effective and equivalent.
Yes, and as I've addressed you on, for example, in Three Rivers under the 1977, there was no reference to are individual depositors given a civil remedy? Is there a duty of supervision for depositors? Or in this context, I've addressed you on why Article 3 and Regulation 4 talk about providing supervision.
Yes.
And all I can say is, in my position, that is the way to look at it.
Yeah, well, I think that's clear. And for my part, I think it would be a good idea if you park it and refer to it on reply, if you need to, once you've heard the argument develop. But we've got your points up to date. Now, do you want to say anything about what's left?
Just, if I may, on the equivalence point, because if your lordships ultimately are with me on that there is a right and you have to compare. There is one issue then, which is what is a similar action of a domestic nature?
Yeah.
The respondent takes issue with that. The Preston case that you've got in the authorities bundle, tab 17.
Just before you get into that, I mean, just articulate the basic point. The basic point is that you say that because of the mandatory nature of Article 3, and on the premise it confers an individual right, it's a breach of a statutory duty which confers strict liability. And negligence is therefore a different form of liability because it involves reasonableness and practicability and so on, which is not the position under Article 3. You say, therefore, there's a gap. And therefore, that's where a direct effect is needed, because you're enforcing something which is not based on negligence.
No, so at this stage, I very much would like to make clear they are entirely direct effect.
I think you should develop, if I may say so, with respect to the law, I think you should develop your own argument. If you're not happy with how the law's put it, I think you should develop your argument as you would wish, and then we'll come back.
Thank you, my lord. All I would just say on that is to be clear, I am saying there is a very clear line between ground 3 direct effect and ground 2 equivalent. So there's they don't bleed into one another.
Yeah, okay.
My position on equivalence, as you've heard, I say that the the comparator is the community law derived right under the regulations only gives you criminal remedy. The domestic right in common law negligence gives you a criminal and a civil remedy.
Sorry, just take this a bit more simply. The comparator in EU law derived right under the directive gives a criminal remedy.
Under the regulations, so under the
regulation.
regulation, work with regulations.
The EU right is implemented leads only to criminal sanctions.
Yes,
Is what you're saying.
Yeah, that's right. Implementing it.
and the equivalent domestic is civil or criminal.
Hold on. Well, if we break that down, if you were to compare the right under the regulation with the directive, neither of them at the moment says you must have a claim for damages. They don't treat it like that.
Yes.
Both have with them criminal penalties.
Yes.
And the question is whether negligence is equivalent to the kind of right that arises from the directive. That's the question, is it?
It is, and so I'll just come on to deal then with the Preston case about what is a similar action of a domestic.
Okay. Tab
17.
Yeah.
And you've got page 823, judgment of Lord Slim. The issue in Preston was where money hadn't properly been paid to trustees of a pension fund. There was a claim to remediation under Article 119, and that was being looked at as whether it was separate or different to a claim for breach of contract.
Okay. So would you like us to read, there's quite a long lined passage here. How much do you want us to read?
Just really at the bottom, paragraph 13 that's been marked up over the page.
Well, it goes on for over 2 pages.
823.
Yes, but the line passage goes over page quite a long way. Which paragraph number do you want us to read in Preston?
Yes. Starting under 14 at similarity,
Yes,
really 14 and 15.
right.
And then once you've read those over the page, you've got then paragraph 22.
Is it paragraph 15 that identifies the question? What's the
That's
first?
the test.
15, isn't it, really, is the test?
15, yes.
Yes, that's right.
It's the purpose, essential characteristics and cause of action.
Yes. And then over the
You
page.
said 22, did you?
Yes, 22. Lord Slim went on to find that the claiming contract was sufficiently similar.
They're plainly different, but the substance, the eventual benefit is sufficiently similar for present purposes.
Yes.
But you've got to start at
Different.
22. The essential matter here is that monies have not been paid to the trustees to purchase pension rights. And the claimant under Article 119 obtains full access retroactively to the scheme, so you can get the money. And a claim in contract would be a damages for the failure to pay the sums.
Yeah.
And he's saying a pension action, call it like that, under 119, or an action under 119 to get equal pensions is not dissimilar from contract, because in each case you're trying to get a sum of money.
Yes.
And critically, he uses the word those sums. So the sums you would be able to recover retrospective and prospective under 119 would be the same as the sums you could recover under contract,
Or sufficiently similar.
or sufficiently similar.
They're
Yes.
different means of making sure that your pension is funded.
Yes.
Okay.
But
So then if we take, so that's the example given to the principle or the question asked in paragraph 15. So,
that was the answer on the facts of that case,
Yes.
which I say is very instructive to the facts of our case, in that the House of Lords did not take an overly rigid technical approach, and indeed on the passage that we've looked at over the page on 826, what was looked at there was the eventual benefit to the employee was sufficiently similar for present purposes.
yes.
And I should say also for completeness, on page 830, you've got Lord Clyde's judgment.
Yeah.
And then over the page on 831 at para 44, particularly then at F, he goes on, I say, to agree with what Lord Slim said, And then at paragraph 45, he continued to say the principle of effectiveness wasn't breached anyway because the treatment was no less favourable. But applying that, if a claim for breach of contract and a claim under Article 119 are sufficiently similar because the benefit is to get the money you're entitled to under your pension, also on our facts are they sufficiently similar? I'm injured from defective or however you phrase it, work equipment that I say is not appropriate. I sue for damages, I'm entitled to compensation.
But you don't get damages for injury from defective work equipment. You get damages if A, the employer owes you a duty of care, B, he's failed in that duty of care, and C, there's a breach. It may well overlap because the subject matter is the same.
Yes.
The duty of care is to provide a safe work environment. The breach is not providing safe work. But juristically, the two are very distinct.
Well, taking the approach that Lord Slynn did in Preston, he looked at the eventual benefit. The eventual benefit under either cause of action is to get damages for the fact I was injured by a piece of work equipment. And stating the obvious, but of course we are talking about whether they are similar. We are not talking about whether they're identical.
Sufficiently similar.
Yes, yes. So you've got a double helping of margin of appreciation there in terms of how you look at it. You don't have to look at are they identical, and it would be wrong, I say, to be overly technical about it, particularly in terms of the causes of action. I take my Lord Justice Lewis's point entirely, but you look at the eventual benefit; they are sufficiently similar.
Do you just look at the benefit though?
I'm not saying you have to. I'm saying that's what Lord Slynn did, and that would be an appropriate thing.
Well,
to do.
here, I mean, the difference is strict liability, isn't it, versus all that comes with the duty of care and breach of duty of care.
But as an employee, I'm injured by work equipment. I want compensation for that injury, whether I get there through duty of care, breach of duty causation, or whether I get there through breach of statutory duty causation.
Sufficiently
same
similar.
point. Yes.
The worry that I have is by telling us in 15 it's got to be purpose, essential characteristics and cause of action, and then by the very careful analysis of what you were getting under 119 and what you get under an action against the trustees being exactly the same money, doing the same thing, i.e. you get the pension contributions defined by a different label to put you in the pension. I wonder whether you can be so glib because frankly, any claimant, all he or she wants is money for what he's. Oh, sorry. Any claimant wants money for what he or she has suffered.
Well,
They don't really care what the label is, in my experience.
no, but it's not clear because you're comparing the conditions, the procedural conditions. What is the reality? Somebody goes to court, they win on liability. The judge looks at the Judicial College guidelines and says, "What are your
Yes,
damages?"
but you see, it's purpose, essential characteristics, and cause of action.
Yes.
Purpose, you may be, that would seem to be right. But what about essential characteristics? Doesn't that bring in, isn't the distinction between strict liability and duty of care, etc., mean that those are different characteristics, aren't they?
Can I just be clear as to what we mean by duty of care? I mean, duty of care is
Well,
sort of a
Duty of
breach of statutory duty is breach of a duty. So
okay, so it's a duty. It's a
Yeah.
failure to provide reasonable care. It's a quality. It's not.
it's reasonable. Yeah.
It's not strict.
Yes,
That's why the
common law
failure.
negligence.
That's why your agreement that there's no negligence in the sense supports you. You know there's a gap. You can't win on negligence, but you might win on a stricter breach of duty,
Yes.
which is strict liability,
Yes.
just the failure to provide the system.
Yes.
So you say the comparator is breach of a directive, which on the terms is a strict duty. What you're lacking in domestic law is just breach of statutory duty, which would be strict in this case.
Yes, in practical terms, yes. Obviously, being pedantic, just to reinforce the point that, of course, we are simply saying Becker didn't coffer. This is the right.
Understood.
But yes, in practical terms,
But you're saying there is no remedy in English law. Ironically, it's been removed, but after the removal, there is no remedy. So the equivalence would be a case of breach of statutory duty, which would be strict on the language of Article 3 or Regulation 4. That would get you the result you wanted.
It's not there.
But it's not there. So you're therefore forced back to negligence, which is quite different, which is fault-based.
Yes.
But you say that Regulation 4, properly interpreted, is not fault-based.
No, it's not necessarily entirely strict, but obviously it is a lot more difficult. So in Hyde and Steeplechase, there's talk there about the employer must positively plead that it occurred due to unforeseeable circumstances beyond their control. But yes, it is obviously
Okay.
a much stricter test.
It is stricter.
Yes, and we accept that on the negligence test we don't meet it, but we say we meet the stricter test.
But the essence of the test, the essential characteristic, one is fault and one is strict.
Yeah.
That's the difference between the two.
Again, the point about it's sufficiently similar, it's not identical. The point about the damages, again, the essential characteristics of the two proceedings, again, I say your lordships are entitled to look at what does that mean in terms of the procedure of a claim. A claim is issued probably in the county court before October 2013 for negligence and or breach of statutory duty under the regulations.
Doesn't the need to have established fault mean that it's a different essential characteristic, or are we being too picky?
Well, I'll flesh that out a bit if I may then. So at Hyde at tab 5, my position is it's not strict, it's just stricter, and I do say that means they are still sufficiently similar.
I struggle a little bit with the concept of equivalence as applied here, because in domestic law you have tort of negligence and crime. You do not have breach of statutory duty, which is stricter. Under the directive, you say you simply look at Regulation 4 as an implementation of Article 3, you apply it, you say it's stricter
Yes.
than negligence, so there's nothing in English law which is equivalent, because you've only got negligence and crime.
My position is simply community law. Previously, you had your criminal remedy and your civil remedy, which was given effect by a breach of statutory duty.
Yeah.
So the comparison is criminal and civil. For a domestic law, you had negligence, so you had your criminal, and you had your civil remedy. The fact that the two civil remedies, one is breach of statutory duty, one is negligence, that doesn't render them dissimilar. They are still sufficiently similar.
The problem that I've got is you could approach this from a quite different way. What remedies does somebody who's injured at work get? Whether you look at the regulation or the directive, the fact that he's broken the words of the regulation, the directive doesn't get him home. He's stuck now. If, however, the facts, which would be relevant when you're looking at either document, also are capable of giving rise to a negligence claim, then he will win. So there is the same possibility for using the facts giving rise to a breach of Regulation 4 and the facts giving rise to a breach of Article 3. The same facts, if the elements were there, will lead to a remedy. So there's no non-equivalence. What you would like is the old system of automatic or strict liability, rather than using the facts that as a basis for saying, well, he knew he should have provided this because he knew he should have taken care to his employers. That's another way of looking at it. There's no non-equivalence. It's just, you say, pretty poor equivalence, poor worker suffering.
But the community law right, in whether vindicated through criminal or civil law, is still the same as it was under the regulation, not to be provided with work equipment which is not suitable. Therefore, the relevant comparison is to look at the procedural conditions then for vindicating that right.
And ask yourself, if somebody wasn't provided with the right equipment and had never heard about EU law and wanted to bring a domestic law action, what would he bring? And the answer, negligence. And he'd say, look, an employer does owe me a duty of care to provide equipment. And now, after 2013, if he's doing that for the directive, he's doing exactly the same thing. He's taking virtually the same words and saying that gives rise to negligence. There is no situation in which you're getting more for the domestic right as compared with the EU right. In each case, if you get anything at all, it's because those facts generate an obligation of negligence.
But the principle of equivalence comes down to EU is granting certain individuals community rights and is saying the member states can choose how they set the conditions for people to enforce those rights. That's up to the member states. You have a discretion. But the principle of equivalence says it cannot be less favourable.
Yeah. And how is it less favourable? what does somebody else have? They don't have a breach of the regulation, they have negligence. Well, your client had the chance of negligence. He had exactly the same rights in relation to the provision of exactly the same equipment by exactly the same employer, and he couldn't establish it.
But
So
that's not part of the test. It's not part of the test to say, is the community law OTOs anyway, because it doesn't improve upon your rights under domestic law. It is just saying we are giving individuals these rights under community law. They
But
have to be.
they're not as good, or there's better rights given under domestic law. And that's what I'm puzzling about at the moment. I don't know what better rights you've got arising out of these facts under domestic law.
But I really perhaps going in circles.
I'm wondering,
going
I
back to
mean,
what you mean by
when-
rights.
Do you want just to, and we've interrupted you quite a bit.
We've never got to hide, have we?
No, I think we need to be, it is the problem of having judges interested in the case, Mr. Carter, which is better than having them not interested in the
Absolutely.
case. You may think not at the moment, but I'm sure you that's doing the
No, well,
So would you like just to set out your stall on equivalence?
yes.
You're referring to Hyde, and we won't interrupt, and then we'll come back if we have any points after that.
Yeah, so in Hyde at 259,
Yes.
this follows an analysis of the regulation. Effectively, the regulation had introduced the concept of reasonable foresight, which is in Article 3 of the directive. And the court appeal in Hyde was having to look at how do you marry the two.
Yeah.
And the answer in 26 and 27 is that it's not reasonable foresight in the common law sense.
Should we just read 26, 27? Would that be a good idea? Thank you. Do you want, if you want to sit down, please do. A moment. While we do this. Yes.
So the point really, the reason I'm referring to this is that the community law right is not strict liability, it's just stricter. And so when looking at similar actions of a domestic nature, it's not apples and oranges if one is strict, one is fault-based. They are both fault-based.
Is the important part of this the adaptation of Lord Roger's words in Rob? Or is that a red herring?
Well, I would say it's a red herring, particularly because it refers to the regulations, and I'm just conscious that certainly on my ground 3, direct effect, we are just talking directives, so I'm just very conscious of trying not to muddle the two. I would say it doesn't take us much further, it's just showing the context of all of this is saying the regulations have reasonable foresight. What does that mean in context? The context is EU law. It's not common law reasonable foreseeability. That's all this is saying. But the point is, obviously, as I said, it's not strict liability.
That's sort of a point against you. I mean, in the sense you get to. I mean, let me just say, you get to this point. You say, my client was injured. There was no safe system of work.
Yeah.
I can't win on negligence. Yeah. But the test in the directive, as implemented into Regulation 4, is stricter, and therefore a more onerous burden on the employer. And therefore there is a gap between the two, and I therefore need to be able to apply on what I say is the straightforward interpretation of the directive, which is a tougher burden on the defendant.
Well,
Which is why negligence, you say I can rely on that, because the remedies which are available to me in domestic law are not adequate. And if I was able to rely directly, effectively on Article 3 or Regulation 4 interpreted in the light of direct effect, I have a sharper weapon to hit the defendant with because it is stricter.
Well, a rational person will obviously choose to adopt whatever they think is their stronger argument. But to be clear, one doesn't have to be stronger than the other. The principle is, if you've got a community law right and a domestic right, you should be able to choose between them, and
I
one should
understand
be
that.
less favourable.
Yeah. Okay. Now I'm very conscious we've
Okay,
interrupted you,
right.
and you said you'd be finished by lunch, and I do want to make sure, Mr. Carter, you have absolutely every opportunity to say whatever you want to say in the 20 minutes you've got left.
Yes, Michael, thank you. I've addressed you on similar actions of a domestic nature.
Yep.
I think the only other point to make, which I think in truth may not add much at all, but simply because Mr. Justice Eyre had relied on the United Road Transport case, I just raised that wasn't actually a principle of equivalence case. And that can be seen in the authorities bundle tab 14 at 765. And at the bottom of 765 at paragraph 38, counsel for the claimant in that case had acknowledged that actually that case didn't fall within the ambit of the principle of equivalence. That was because actually it was comparing apples and apples, it was comparing two sets of community law rights.
Right.
So I just flagged that because it was referred to by Mr. Justice Everett. In terms of just tying together then principle of equivalence, obviously we say similar action of a domestic nature. The principle of equivalence is not a threshold test in the way effectiveness is. It is just, is it less favourable? I say it is less favourable because you don't have the choice, and so our position is simply, as I say, your community law rights are less favourable. And just to be clear as well as a final point, obviously the way events happened, there was civil liability and then that was taken away. Nothing turns on that. We're not saying because there was previously gold standard, you've got to maintain gold standard. We'd be saying the same thing, even if the regulations had only ever provided criminal remedies. So I just raised that. It's not to do with gold standard and taking away. But really, my lords, those are my submissions on principle of equivalence.
Thank you.
In terms of ground one, I skipped over at the beginning. Would your lordships like to address me on you briefly? I mean, obviously our headline point is Mr. Justice Eyre, by both sides, unfortunately, was referred to red.
Yes.
Which didn't.
Is there any disagreement between you on ground one?
There's
On
not
the
a
interpretation point, I mean, it's clear from the authorities, isn't it? As analysed by Sir Julian Flo, was he? I can't remember. He was Flo LJ or as Chancellor. Forgive.
Was for
That's LJ.
Lord Justice Flo. That it's disjunctive,
Yes.
and because unfortunately, Mr. Justice Eyre was not taken to that.
Yes.
So we're agreed it's disjunctive.
Yes.
Does anybody? What is the disagreement between you?
Yes.
Is there a disagreement between you, Mr.
There is a bit of a disagreement between us
Okay.
in that I would say that Lord Justice Flo, in referring to the Advocate General's
Charleston?
In Farrell and Whitty, where she said
Okay, there is a difference.
there's a difference.
Well, in that
Do
case,
you accept or do you not accept that it's an emanation of the state? That's the question.
Yeah, I don't concede that. I don't accept it, and my submission, to the extent that this is a material issue on this appeal, and that in turn comes down to your conclusions on grounds 2 and 3. If emanation of the state is a material question, then we would say the evidence that was available
was insufficient.
wasn't sufficient.
Okay, fine. Well, thank you, Mr. Chum. Okay, Mr. Carter, you better develop your argument.
Yes.
In whatever way you want, and we will keep quiet from now to
Is there a
tomorrow.
respondent's notice challenging the facts found by the judge below?
No. No.
Right.
And so I recognise, my lords, that if you were to conclude that the facts as found are sufficient to conclude that my client is an emanation of the state based on a proper application of the law, Farrell and Whitty, etc.,
You're stuck.
then I'm stuck.
Thank you. Right, now, Mr. Carter, we will keep quiet. You develop ground one as you want in the light of that indication from Mr. Chapman.
Thank you. Yes, well, I can deal with it very briefly. Our primary case, as set out in our skeleton, is just Mr. Justice Eyre reply. He found the first law was satisfied. That's not challenged by a respondent's notice, and Lord
That's
Justice
enough.
Flow makes clear that's the only requirement. I will just briefly deal with our secondary case, but again, it's really just what I've summarised in our skeleton. Before I do that, I'll just say it may not be taken in oral submissions, but in the respondent skeleton, they have said that it's still a nuanced and intensely fact-sensitive issue with factors pointing both ways, but haven't, as I can see, identified any factor pointing anyway. So the secondary case, which is if there is required to be a special power, it is a red herring, as Lady Justice Andrews thought when granting permission to appeal the question of evidence. It is just a question of law. And as I've set out in my skeleton, the references from Tajeri, from Baroness Hale, that you have a statutory framework that says we're making regulations, you can lend money out under those regulations. That's a special power that if I'm a bank and I want to lend money out of public funds, I have to go and reach an agreement, probably in the law of contract, with a government department to do that. I'm not lending funds as of right out of a statutory framework, and so that's the special power that the respondent has that no private person can have. And again, the collection of the funds. There's a statutory and regulatory scheme where HMRC then collects repayments akin to income tax. Again, if I'm a bank and I want to lend money to students and I want HMRC to collect it, I have to reach some agreement with HMRC or some other government department. I can't just lend money and that is done under the statutory scheme. And so on the law, nothing to do with evidence, on the law, the respondent has special powers that go beyond those of private persons. But if it's necessary to consider both of the test, that's our case. My lords, that then does deal with all three of my grounds. I can see we've got a bit of time left, but subject to any questions over my submissions.
Anything?
No.
Well, Mr. Carter, thank you very much for your submissions and for bearing with us on our interruptions. And if there is anything that you feel on reflection that you haven't had a chance to get across because of our enthusiastic responses or whatever other reason, then let us know later. Thank you very much. So, Mr. Chapman, do you want to set out your stall, as it were, before lunch? How would you like to proceed?
I would, in light of the way that the submissions have developed, I would welcome, an early-ish lunch.
All right.
And
Well, I have to, I'm afraid, have a short. You have meetings too, no doubt. I have a meeting at 22, so we can't start again until 2. Will we still be able to complete everything
oh yes,
by 4:15 this afternoon?
and my lord, my idea in taking the early lunch is that over the lunch I will be able to refine what I intended to say.
Right. Well, thank you very much. Well, in that case, we will rise now, and we'll look forward to seeing you at 2 o'clock.